right, we have a quorum. Okay, first matter to address is to consider final adoption of an ordinance to establish a hearing bureau and administrative procedures to adjudicate code violations related to blighted and abandoned property, public health, housing, fire prevention, and the environment, and other matters with respect thereto. Okay, is Mr. Smith here, or who's going to talk about that? Okay.
I'll start. Kay, you want to come up and this is on adjudicate. I meant on the hearings. So I'll start the general. Daniel may want to come. I think Kay can handle it. Here's some of our talking points. Mr. Lawverdane, Mr. Chair, I think that you've been as the key point of contact on the council briefed by Ms. McGills and Daniel Smith earlier or in the last few days. The idea here is we've seen some challenges when we try to take a next step in city court to do some adjudications there. You know, the particular hotel, motel that we've had a lot of challenges with in moving toward there. And Mr. Chair, while a great idea and a potential help, and this is no criticism of the court, its personnel, or anything it does, courts are better equipped. They can handle misdemeanor things. They can handle the criminal side, but to handle all the problems that come with notice, enforced errors, and other things that can come up, probably not the best, even though maybe later it could be helped. The ALJ idea would be to have, instead of the council hearing appeals, we would set up with properly hired, participated in by all of us lawyers in town who maybe in a perfect spot in their career could be the administrative law judges, and move that docket along, if you will, make findings of fact, applied against the law, and then direct appeal those to the district court, and that would really help us move these things along. That's the general.
So let's back a bit. So
Yes.
just for the people who are here and the people who are listening, this process is designed to deal with blighted property.
Correct.
And how does this process address blighted property?
I will turn it over to Ms. McGills, or we'll turn it over to Dan.
Okay.
Sorry, I was a bit late. I thought this committee was at 4:30. I apologize.
No problem, sir.
So the upshot is this is to allow the administration to have a hearing officer to levy fines and fees against property owners for having blighted properties.
Okay.
Primarily be used for blighted properties, but it does also authorize for violations of public health, fire code in particular. The fire chief has expressed an interest, and we have dangerous situations to also bring this before a hearing officer. But by and large, in the way we've written it here in the first iteration, we'd like it to have to go after blighted property.
Now, when you say public health, what do you mean by that?
The city does have a section of sanitation, public health type ordinances. This would be a pretty rare situation, but
Someone not
People
having
who-
water hooked up. Someone,
discharging, thank you. We have had situations in town where people did not have their utilities cut on and they were discharging sewage in a unsanitary manner on the property.
Okay.
That'd be an extreme situation. But by and large, yes, it would be for properties that were in blighted condition, to be able to have a hearing officer independently make that finding, which would then allow the city to do initially a small fine, or also give the person an opportunity to tear it down or fix up the structure, right? This is to sort of provide that carrots and sticks approach to bring them before a hearing officer prior to bringing them before the council, where you just have sort of a condemnation situation. Try to intervene in some of these situations where people do need some incentive. And then also for commercial properties as well. We're not strictly talking residential.
Now, condemnations, will those still come before the council, or those?
Yes, sir.
Okay.
Yes,
So
sir.
this works in conjunction with condemnations?
Absolutely.
And these would be in-rem judgments.
Right.
That would attach to the property, not.
Now, for laypersons, what does that
Right.
mean? Explain it to laypersons.
So you have a personal judgment and an in-rem judgment. Those are the two main types. A personal judgment would be against the individual, as it sounds. Those are situations where people can go after other properties or go after garnish their wages, their other assets. That's not what would happen here. So this is just a civil, non-criminal judgment that would attach to the property. And then, the enforcement goes by just that property if it's able to be, if there's a lien is placed on the property is the form of the enforcement.
So for
But it doesn't follow the
non-lawyers-
person around.
So for non-lawyers, what you're saying is the city can get a judgment that will go just against that property.
right.
That's correct.
As the property could be traded around, someone would have to cure that issue if they were to acquire it with that. That's where the money comes in, as opposed to a personal judgment on an individual where they have to pay it, could be garnished or anything else. It doesn't do that.
Now, is the city contemplating having to seize properties and sell them?
That would be, that could be an ultimate remedy. Now, the state law that authorizes this does not allow that procedure to occur against properties with homestead exemptions.
Okay.
So your personal property is sort of protecting that. You can still file a lien that could show up on your taxes as with any other lien, governmental encumbrance.
So if my memory serves me correct, homestead exemption applies to the first 75,000.
Sure, but this is more if you have the status of a homestead exemption. So the assessor, independent from the city, determines whether you get a homestead exemption. So basically, it's if you're a bona fide resident of your own home, then for these types of liens, there can't be a seizure and a sale. But for like a blighted commercial property where someone's just sitting on it, it's falling apart, the city would probably want to ultimately.
So practically, most of the blighted properties will be worth less than $75,000 residential.
Right, well, the liens, though, would be way less than that
Yeah.
on a residential property. So it's not so much the exempted part of the real estate taxes, it's to satisfy however much that lien is.
But it seems like the city really will not be seizing any properties with homestead exemption on them.
Well, that's correct. That
you couldn't
is
anyway.
allowed.
Yeah,
Right.
I know, I'm just.
Yeah, sure, yeah, of course. So I think a best example, let's say, and currently the city has the ability to do that same kind of seizure and sale with a judgment from the court to enforce a demolition lien. But after we do the condemnations, city comes back a second time, asks for authorization to file the liens. Let's say there's a $10,000 lien that's been filed. The city does have the right, we're looking into doing that more, but to get a judgment from the court and proceed and do a seizure and sale for a demolition lien that you guys authorize at a condemnation. This would be a separate type of lien. The city wouldn't be owed anything for money it's spent to a contractor, but there would be these fines that the hearing officer would levy as the penalty for violating the law, the violation being having blighted property. That in some situations, a truly abandoned house with its known homestead exemption, but really more likely commercial property where there is possibly some saleable value, there's some, the property could be worth the lien. In that case, you would, if someone really never paid and just abandoned the property, that is the way to get back into commerce is
And
to,
there's no homestead on commercial property.
exactly right, that's correct.
And also, homestead expires when the owners pass, unless the heirs take
Sure.
it on and then they claim homestead. So
I believe so.
that's a possibility.
Okay.
Okay. Now, walk us through the process from start to finish.
Right.
Just give us what we did in law school, a
I'll
fictitious.
try to,
A hypothetical.
Okay, sure.
Give us
So-
a hypothetical.
the city sends a lot of letters already. So let's say this is a situation where there's a blighted gas station that's been abandoned, or the city believes it's blighted and wants it to be determined as blighted by a hearing officer. So this is spelled out in the statutes too. For anyone paying attention, it's Title 13-2575 and 13-2576 lays out the entire process, and that's where the ordinance is developed from. So say first you get your courtesy letter, people throw it in the trash. You get your second letter that says, no offense, now the second letter has, you need to come appear on February 1st, whatever, before a hearing officer. We've now set a date for you to appear. And that notice, which would be sent by certified mail to the owner, and if it's a blighted property, it also has to be sent to all the mortgagees.
Okay.
In a commercial situation, you could also send it to the tenant, because a lot of times the tenants in a commercial situation are ones responsible for the condition of the property. It would have the date they could show up. It has some protections. It says, if you want to send in some documents, you're going to fix it ahead of time and prove to us, we can just not even have the hearing. People will more than likely show up to the hearing. It does also say, and it's authorized in state law, that if you don't show up and you've gotten that notice, you can still be found liable for the blighted property.
Okay.
So then the hearing officer would open the hearing. It runs by normal rules of evidence, although because it's an administrative hearing, it's a bit more relaxed. That's correct. But you still have to swear the witnesses. Everyone gets an opportunity to present their case. The hearing officer would find the facts. But in a lot of these situations, the facts themselves are going to be pretty clear. You have like an inspector with a photograph and an inspection report.
Okay.
And the city's going to go after the low-hanging fruit first, where there's very clearly blighted property. If there's going to be any arguments, it's going to be over notice and that kind of thing.
So in essence, when the homeowner shows up, he or she will be presented with some type of inspection report showing
That's
the
correct.
houses in
Right,
bad shape.
so to get a little more granular, typically these hearings, you'd have the hearing officer would first swear in the city official, make them prove notice, here's the green card or whatever. Then it's, show me, like, Mr. or Mrs. Inspector, is this, there's going to be a report, they'll have to authenticate the report, authenticate the photographs. Basically, you have that witness there and saying, yes, I did indeed on that day go out and I took these photos, we took them more yesterday, nothing has changed. That's almost the extent of the city's case in in a blighted property hearing. Then, of course, the owner showed up, or if they sent a lawyer on their behalf, that lawyer could then, argue either they didn't get notice or whatever their defense would be. And a lot of times, these can be people, and you guys have seen this in the council of condemnation. Someone shows up and says, couldn't find a contractor, there was just a storm, XYZ, can I have more time?
That was going to be my question.
Yeah, and that's pretty common, and I think the city would, and this is a hypothetical, like we're in law school, the hearing officer likely would say, well, city, what do you think? And the city could say, well, they could come back in 30 or 60 days, and they've got a signed contract, and they pull a permit. That's your kind of sticks and carrots, hand-holding someone through the process, but if they get an extension of time and nothing's happened, then you might see, this initial judgment.
A question before you continue. So the hearing officer, they would have the knowledge needed to understand that if the individual comes and says, oh, I need 30 days or 60 days or whatever, okay, is this even going to be a reasonable request to actually fix something or not? Like,
Yeah, that-
I think, because sometimes for us up here, we haven't actually gone
Right.
to the property, and so when we have to make those decisions, sometimes it becomes challenging. But I think for the hearing officer, would they be very qualified to?
Well, yes,
Look at that.
One thing I can say to that, Councilwoman Felter, the hearing officer will more than likely have a docket, and it may be incumbent upon that individual to go see some of these homes himself, although that may be some liability with him driving and being a wreck, but
so the hearing officer, we're likely going to have it selected by an RFQ. I mean, they're really the judge. So
okay.
frankly, the hearing officer shouldn't be going and doing their own fact-finding, right? It's the city's,
It shouldn't be, but
well, and they shouldn't be doing ex parte communication either. I mean, you want this person to be independent, unbiased, but it's up to the city, just like in a court, to prove the city's case. The city will have the burden of proof, so to speak, that it's blighted.
okay.
Yeah, one of the things,
Now,
Mr. Lawberdane, is it adds I mean, you're adding a layer of due process that gives those folks a chance. I mean, you're going to have notice proved up in front of somebody who's not just works for the city that way. They're a lawyer who takes an oath to act as an ALJ. They swear to be impartial. They have to do that.
And I
do-
saw that there's a 2-year requirement.
Mm-hmm.
and that comes out of state law.
Do you think we should do more, or?
We could. I mean,
I'm just throwing it out there. I mean, what are the pros and cons about that?
well, state law, I mean, of course, opening it up to the greatest number of people, but, I mean, state law allows it to be
There's little.
at least two, right?
Okay.
We would, of course, in our RFQ, would want to put in, real estate experience or something in there to show that that you do have, as you said, some kind of expertise in that sort of area of law or that practice. I mean, it is something we could put in the RFQ. If you guys wanted to put it in the ordinance, that's an option.
We have something under this deal of the owner of the property that's before the judge.
Mhm.
Where do they appeal the decision?
District court.
That's correct, and that's provided for in the statute.
Well, it's all-
And that'll be reviewed, and this is interesting, I mean, it gets reviewed on the record the hearing officer develops. So that's really the hearing officer's job, of course, is to determine whether it's blighted or not, but their job is really to build that record. Have a clean record for if it does get appealed, that the testimony's clear, the documents were authenticated and introduced correctly, that everyone got a fair shake, of course.
And who hires all the court, will there be any personnel also?
So we believe we can, maybe I can defer to the administration, but they seem confident that they can handle it with existing personnel, because they already do send a lot of those notices, the condemnation notices. The learning curve would be kind of getting people trained up on the procedure, but it doesn't require a ton of city staff.
Okay.
And if we needed
Sorry.
a reporter, you could always hire, just like you do, you get a
Well,
court
it has
reporter,
to be
like you get a
recorded.
deposition. But if we want to establish someone at the court already that does that and work that out with the judge to But we could do that if we need that separate.
But
Just thinking out loud.
yeah, it does need to be recorded. I mean, that's a requirement. There has to be
Has to be a record.
a record. And, I mean, this is, 20 years ago, they would, I'm sure when you were a young lawyer like myself, they would break out the cassette and they would really just
Yeah.
click that record button. Nowadays, of course, we would have video technology and
All right. Now, something else that kind of dawned on me. Is there any way that neighbors adjacent to this property could also be informed or receive some type of notification to say, hey, that house next to you is going to blight court? So people can know what's going on around them?
I mean, we certainly could do that. I mean, they do that for like the Board of Zoning Adjustments. I mean, a lot of times these cases are made, it's brought to the attention of the city by neighbors, and people can appear as witnesses.
I'm just.
Now, I will say this, we have in the ordinance a requirement that the notice not only be mailed, but it also gets posted to the property,
Yeah.
if it's, safe to do so.
I guess.
So in that sense, if that notice will go up and you can,
Chair, do you want people to know so that they could
Well, that-
testify?
Well, that they will know that something is going on to remedy the
it
situation.
does need to be posted to the house before the hearing.
Okay,
so-
I'm talking about the neighbors, like neighbors who have to live day to day with this blighted property. I'm just thinking, is there any way we can kind of let them know so they can say, hey.
You
I
look
see-
like you think there's a negative.
Would that be against their privacy, though?
Most often,
It's public
that's
record.
how they come to our attention in the first place. And people continuously call, they'll call and report it,
Okay.
and they will follow up,
Okay.
believe me.
All right, I just want to make sure
They
there's a
will
mechanism.
generally be informed.
And Madam President, given the fact that we're dealing with city business, privacy is not a concern at all. This is public record.
Yeah.
Unless I'm over speaking.
Mr. Chair, I was just trying to
That's
figure out if
correct.
you're wanting to, so I'm seeing two ways you could look at it. One could be you want them to get notice so that they would, A, know something's being done, and B, maybe they want to go testify. The only negative side, it's kind of what you were saying, Madam President, but it is a public record. But if you were to give everyone notice and you had a recalcitrant owner or whatever, somebody there that was causing trouble, and they knew everyone was getting noticed, they may go put undue pressure, or I want you to come testify for me, and then that causes even more strained relations. I don't know the answer to that. I'm saying one could make an argument either way, that the giving of the notice to neighbors would then maybe put them in the crosshairs of a
Well,
bad neighbor.
if I may make a comment to that. So, state public record law does contain an exemption for people who make code enforcement complaints. I don't know if people know, but it's not very, very well known, but you can't call the city and say, hey, he ratted me out. The city will say, well, you're on our radar now, we went and looked ourselves, and it doesn't matter. So the city will be the city bringing the case.
Well, that's kind of what Cynthia was asking.
Exactly, yeah.
You could, even if you got around that exception, you could post it. I don't know.
I think
Sure.
I'm overthinking that. I don't either that.
That's all right.
When you post the notice to the house, is it like a red paper or something?
Well, we haven't developed all that
Oh,
yet.
okay.
Typically, it would be just a copy of whatever they would have sent to them in the mail that would be affixed to the house. Now, a lot of these buildings already probably have an uninhabitable placard that this administration developed in order to let people know, let unhoused folks or anyone else know that they're not supposed to be there because it's
Yeah.
not safe or there's not utilities as a mild deterrent. A lot of times those people don't
Or an
have
invitation
legal.
to move in.
Yeah, well,
Right, well.
this of course, this is another tool in the toolbox, and we think it's an important one, so we appreciate it.
Do we have any idea where these hearings will be held?
Not at this point.
Not at this time.
We haven't developed.
My lean would be, because of the equipment here and what I'm about to spend, because I can't take it anymore, we got to fix it, even my briefing, we got to get this right. This is a great room for it, obviously, it could be set up to be that, but if you didn't want that for any reason, we can talk about that offline, or online.
And something we'll recommend
We
is.
could outfit, Bolton could be outfitted, there's a few of the community centers that could easily be outfitted to modularly have it set up for that day and move it out, like have that equipment back and forth. Obviously, because of the cameras here, you could make a full record of everything. And you could pick it on a day that's least inconvenient to anything that we do. But if you don't want the extra security and other measures you may have to take, to the extent you do, I'm not sure you do, but whatever they are, we could entertain something else.
And
Are
and I-
these hearings open to the public?
Yeah, that's all
They would
public
be
record.
public
Okay.
record. And,
But-
well, and so some jurisdictions during COVID in Louisiana, they really upgraded the telecommunications software. So a lot of these places will allow people to appear virtually. If you have Zoom, you can do it by link. That's something we would
do have the
look
courthouse,
at.
the city
you know.
court, that's the cities, we'd have to be a lot to work out on if you could. And there's probably some hearing space at the Ninth JDC we might could cooperatively endeavor with.
I don't know about that.
I don't know. Well,
No, in the old,
we'll work it out. It's about convenience. This
the
isn't
old
about.
police jury part, if they haven't, I don't know what that status of that is, but I don't know.
Yeah, we would, and look, we would want, the purpose is to get people in and get them compliant. It's not a gotcha, it's not a kangaroo court. So we would want to do things that would be most accessible, I
So
would
we still
think.
got some more I's to dot,
Yeah.
T's to cross.
Yes, sir. But this is the first step, is getting this ordinance in place.
Can always be amended.
That's true. And a lot of this will be done by policy or procedure.
Right, it seems like a lot of the procedural things would come later.
And so these are the,
We may want to have some guidance with LJ, like on a first visit by someone, you should consider, you don't want to tell the judge, you don't want to say, you must, I want a sentencing guideline like that problem. But it may be on a first visit to the court, if someone presents these things, the ALJ shall consider the following factors. If the city admits that this is their first time, they haven't not complied before, et cetera, they may get customarily an additional time. But you always have to be careful what you write in is then the policy for all, and it makes it harder for there to be discretion. So you can overwrite that, overthink.
Yeah.
It just, you have to figure through that.
There is a safeguard like that is in the ordinance, and that's that even though the state statute, like a lot of things, you see this all over, every day is its own separate violation, so daily fines. It does require a subsequent hearing. The way we've written the ordinance is that daily fines can't kick in the first time they show up. It would have to be, they would have had this reset or an initial small fine, and they didn't comply, and then you bring them back, and that's when you would maybe
Now,
hit them with something more substantial.
I want to say if fines are assessed, can there be some type of negotiating?
Yes, there can. Absolutely. So this is really a key, this is why this tool is important to supplant the condemnation ordinances with, in my opinion. So in a situation with a condemnation and the city hires a construction company to go demolish it and we get the bill, that is a bill that's like services rendered. You can't just negotiate that, otherwise you run into the Article 7 problem. However, if you're in a situation where the hearing officer has levied some fines, that's more like you're over in court where the DA, so to speak, the prosecutor of the city can say, hey, look, yeah, you got hit with this fine, but if you get it done in the next 60 days, we'll cut it in half. New Orleans has a lien reduction program that is exactly for that. It's sort of a sticks and carrots approach. So these types of fines absolutely can be waived or reduced because it's not money the city has spent that it's trying to recoup. So you don't run into that same Article 7 problem.
You understand that? Lawyers, we understand. There's we got some non-lawyers.
There's more flexibility with it, for sure.
Lawyer there.
If we spend it, it's hard to forgive it because of Article 7. If we hadn't spent it, then it's a problem.
That's right.
So are there any other cities in Louisiana that have implemented something like this?
Basically, every other city our size or larger has this type of ALJ system. Yeah, and other places will do it for zoning. We would have to go to the legislature for that, or they would do it for more property violations, historic district ordinances, like in the French Quarter. Right now, the city's asking that it be primarily for fire code and for blight.
We wanted to get it set up.
Right.
Work the kinks out, then come to you guys next year, and maybe somebody brings a bill for us to add the others. We just thought, let's test this part out.
I think anything to help encourage people to take responsibility for their properties is absolutely needed. Because I know in my neighborhood, when I go for a walk, it's like, you see your neighbors and then, light is so, we just have a huge problem with that.
Yeah.
And hurts me to see our city looking like that, and just the people that don't take responsibility, and the people that do take care of their homes and their properties and their businesses, they suffer because of these things.
Yeah, I see it as a big filter. You have most people doing the right thing.
Yeah.
Then you have some people that need to get a letter, they'll do the right thing. Then some people that need a hearing date, some people that need to be brought in and get that reset.
Right.
And some people are just not either able or willing to do it.
Right.
And those are the
It's gonna
folks that you may end up
But the city
going all the way
is,
through the process.
they're actually demolishing a lot of these
Yep.
houses.
True.
I mean, on our Sunday ride, especially in the Sonia quarters, we're seeing a lot of houses are being demolished in that area. And so I think that's a good
correct.
thing.
Yeah, and the
This would
hope,
give you a way better tool. You'd have a record made. It's just a whole bunch of process that helps everybody.
and hopefully some of these will be caught before it would have to get to a condemnation, or it would encourage more people to take care of it on their own, so the city's not paying money and chasing it through a lien.
So what I wanted to add first to comment on you noticing in the sliding quarters that a number of houses have been demolished there. We are sort of trying to take a zoning look at things and create an impact by not just doing one house here and one house there, but trying to clean up an area. So we did kind of focus on that area this past year, and we are going to look for other houses in other areas to kind of make a greater impact. But remember, the hearing agency that we're talking about is for blighted properties, not just housing. What we want to do, that we talked about the other day, is go to the legislature next year, hopefully, where we can have the zoning code enforcement added and some of the housing code, because we want to really stop the problem before it gets to being blighted. If you've got a neighbor in your carport or your porch is falling off the house, it's not blighted and it's not ready for condemnation, but it violates the housing code. And so we could bring them in to try to make them make that repair before it gets to the point of being truly blighted and abandoned. Or if you have a neighbor that parks a pod in front of their house and it violates the zoning code, and you can't get them to move it, you can bring them to the hearing officer and enforce the zoning code. It's much, much more difficult for them to see court because of all of the procedure that you can get it handled efficiently and effectively through this process. So we do hope to expand our options through legislation next year.
Do you feel that if we implement this, the town in favor of it, we'll be able to get more bang for the buck that we're spending out as far as condemnation and
Absolutely, because you notice now, all we are condemning are residential properties. We've only done a couple of commercial, and that's because, like we discussed, Malcolm, it's so expensive to demolish a commercial property. That would eat up, if you do 2 or 3, it would eat up our whole budget for demolition. So we're going to really focus initially on commercial properties with the hearing agency, and try to get some of those commercial properties taken care of where we don't have to spend the money to actually take them.
Yes, sir, Mr. Trey.
the legal department will have executive in this concept. One technical name, title, to recommend the title, and then we chose the the second amendment is Mr. Washington on page 5. 506.
you'll notice section 7-237, procedure for hearing, paragraph B, is toward the bottom of the paragraph. Mr. Walden is going to request that y'all consider a 30-day notice period rather than the draft 15 days. That's to give people longer notice and longer consistent with the process and fair notice to people.
Trey,
Should we recommend those two things out of the
There's,
to the extent required, although not, but just to put everybody on the same page, the administration concurs in the amendment and considers it making a better ordinance.
Now, one thing that I mentioned to Trey was, let's make sure we have some accommodations for the sick and the elderly and the first aiders.
In addition to concurring in the amendment proposed, it was my understanding from talking to staff, although I didn't talk to the chair, that the chair wished us to consider sort of a list of things like forced errors and so forth. We also concur in that. We would point out that perhaps what you don't want to do is what I talked about at the briefing. You wouldn't want to have that list where they're unadjudicated as that, so they can force you never to get there. But we would commit that.
What do you mean? What do you mean unadjudicated? What do you mean?
So if someone hasn't been declared, so if someone just says, I'm a forced error, you can't do it, and it's never been determined,
Okay.
that can get to be a really big problem.
Okay.
So what we would want to do is, we're going to ask that Mr. Smith, Ms. McGill, to the extent necessary, sit down with the chair, look at that list, and the administration will sponsor those amendments at first time when they're ready. If it's next council meeting, we'll present them. If it takes two, whatever we need to do, we concur with Mr. Lawverdane.
I just sick and elderly
Yes, sir.
and the mill infirm, we need to really make some accommodations
Okay.
for those.
just want to think through sort of how that would fit in, and
Which thing, Mr. Fowler?
something we'll start with.
And Mr. Gist, there was the one more technical amendment right at the beginning in the definition section of blighted property. Of course, it's our luck that the legislature would change that during the process when we're bringing it to you. So there was a citation that we're just asking to be changed to as provided by Louisiana law. So that's already, okay, thank you for that. I just want to make sure it was mentioned out loud.
That doesn't have to be voted, if that's so, does that have to be voted on, or just be voted on when they do it?
Okay, thank you.
What happened was after Damon wrote this several weeks ago, the legislature came last week and changed it again. So
So rather than chase their new statutory norms, we'll just
Donald
say.
and I have already made that correction. That's on page
Exactly.
3, the definition of blighted property. Will read blighted property is commercial or residential premises, including lots that are vacant, uninhabitable, or hazardous, and because of their physical condition are considered hazardous persons of property as provided by the law. That's the current definition of blighted property as it is.
As of this week.
And this whole topic is going through the legislature. As Mr. Lawverdane knows, it's being addressed on several fronts. It's just coincidental that we're bringing this up at this time.
Okay, all right.
And Mr. Fowler, the committee can recommend the technical amendments. Ms. Jones and I are prepared to offer them at the time.
Let's do that, be simpler.
All right, all right.
Now, I want to thank Daniel for doing an outstanding job on getting this pulled together for us. It's a lot of work, a lot of research. He's worked very closely with the
Okay.
planning
Thank you,
department, and he's really become an expert
All right.
in this area of the law. And thank you, Mr. Lawverdane, for taking the interest in it that you have and meeting with us to help us work through it and understand it.
Let's just get to work. Let's
Yeah, thank you.
address it. So I thank you guys for your help and
If
your
I could-
assistance.
If I could also indicate, Mr. Daniel Smith worked in New Orleans with their process, and Mr. Goings and Mr. Smith have been studying not only what New Orleans, but what these other communities have done, and that was put into this initial document coming to y'all. I do want to, I've read it several times, and your legal department's done a very good job bringing this to you at this point.
I'm happy.
I appreciate that, and look, we're not reinventing the wheel. LMA has also done a lot of work on this. This is adapted from A model ordinances, but, we checked everything twice.
All right.
But I do appreciate that a lot, thank you.
Good work, thank you.
Make a motion to recommend as the suggested amendments.
I have a
With
motion.
the suggested amendments.
I have a motion from Mr. Fowler. Do I have a second?
Yes, second.
I have a second from Ms. Velter. No vote. Okay, all right. Did anyone have any comments, or are we beyond that? Ma'am,
I'm sorry,
is there an opportunity for folks to make comments, or?
if you so choose, but normally.
They can sign up for comments at the meeting, too.
Okay,
But in
all right.
committee, y'all, it's
All
not
right,
necessary.
all right, it's not necessary, okay, all righty. Item number 2, to hear an update from the administration on affordable housing plan.
Mr. Chair, we talked before, and I think Ms. McGill's, and again, as chair, you have a sort of a keen and individualized interest, if you will, in these things. We're going to work with you some more. You and I talked about, I was going to spell out what I did at the briefing, sort of a philosophy that I follow at the administration on it. And it is just for all of your thoughts to correct, we can talk about now, or to say, don't agree, maybe you should change the order. But this really would help us. Right now, you have a 5-year plan, and that goes forward. And in the absence of our, and really you guys in this case, this is where your authority comes in, direction to us, then it's left to staff to sort of look at what they consider the best national practices and what they do for their 5-year plan. And so we have the right as the administrator and you as the legislators to say, well, the real thing we'd like to see is this. This is what I personally follow, and I want to add, as I did at my briefing, I am not agreed with universally by staff. They might have a different order, and I'll be brief about, I'll tell you what that is, but here would be my order. The market is optimum, obviously. That doesn't exist for the reasons we talked about. A market cannot drive all housing. People who are full-time employed, dedicated in their lives, right now are having a tough time getting a house and buying it and living. So that's, you can debate on why that is, and I'm not here to talk about that, your politics on that. I would just say it is a fact that that is true. So the first thing we would look at is home ownership is best. So where we have public dollars that we either receive federally or in conjunction with our own, we look at how we can help home ownership. It is, where staff will disagree with me, is how difficult it is to stand up, as they have tried, any project where you deploy dollars into people fixing up homes who are often renting them. You can't get the right incentives. You can't plug it in. So it's tough for housing to be built for ownership with all the things that go in it. But for me, that would be optimum every time. I would want that to be my first. In talking to you as individuals, I said it in my briefing, I'll say again, I think that is the majority of you, if not for sure, probably the case that that's your number one. Followed closely by a mixed income, market-driven townhouse style of home. So now you're talking about rents, but you're talking about bigger places, maybe a little contained yard, a patch of grass to put your pit and all your things to make it a real home. Some kind of nicer townhouse level situation that you can rent. So we're not talking 60, 70, 80 units. You're talking about 30s of units, that kind of thing. LEED certified, hopefully, security, all those things in it. This is me again. I'm not speaking for everybody. My next one would be, again, mixed income as much as you can, still market-driven apartments. And then finally, other models. Pejoratively, people, I guess they say low income. It used to be even more pejoratively Section 8, named for this particular section in the law. Those things that are riskier or have associated risk, let's call it, would be at the bottom of that order. But let me say, they're needed. You have to have it. They're just in that order of, that tends to be more directly federally funded. Those have their own organizations, housing authorities. So that's not our bag really, even though we need to provide support, security and other things. So that's how I look at my own order. I think that's close to the chairs. I don't know that. But if there's guidance to give us, we can recraft that plan.
I'll be giving it to you. And I got a question. We get Brownsfield dollars, right?
Yes.
What are we doing with our money?
What are we doing with our Brownsfield? We're
Yes.
doing, gosh.
The-
Well, we're doing the Russia's Cleaners for one, and we're doing a lot of testing. But we have some money that we can kind of play around with to look at and do some studies for redevelopment of brownfields and that sort of thing.
So,
Specifically, it depends on how the grant was written, and our grant was written several years ago. Do you have some?
I'm just asking, like, I know we get those dollars.
We do.
Are any of those dollars being
Russia's
used?
bad.
Yeah, I know all the chemicals, yeah.
Look,
It can't be used to create housing. Now, if you had a developer that wanted to develop on some property that needed an environmental study, you could do your phase one and your phase two. We used it to do the phase one and phase two on Russia's Cleaners, on Weiss and Goldring, and other buildings and properties.
Rustin Found You had a component along with the Superfund site it had. There was a second component.
That was an old,
Old.
yeah.
Okay.
But again, so you came and said, these are two things in my district. These are two buildings. I think I know one you'd identify. If you came and said that, then they can go look at that specific one and think about how to write around it.
Okay. Well,
But that's not housing necessarily, but
okay.
brownfields would be for more.
Well, I know you guys are doing your homework, and I'm also doing my homework. And I expect us to be meeting in the days to come to craft a policy that addresses a lot of concerns in the city. I want people owning homes, I mean, everyone should get a chance to own a home. And it doesn't have to be a large home, but just a modest, basic home. So that's very, very important to me. I think we can look at the possibilities of container homes, certain modular homes, certain tiny homes. There are a lot of options out there as opposed to just a traditional stick building. And I think we need to really be very flexible and open to any other options out there that are cost effective. So,
No disagreement. So again, for me, you can see some of the disagreement in staff. Kay probably has a different feeling than I do about that particular one. I'm number one on that's my number one too. I do think when you get into modular, containerized, all kinds of other things, there are other hazards. They can be quite a nice sell to a community. They can involve chemicals in the usage of the material. There are lots of things that are, this practice is here and that one's there, but they all get the same incentive treatment, and so you can be drunk with the idea of let's go get it, and it ain't the best idea for your community.
Well,
It also can affect where located, the values of other homes. And that is where you're going to get some pushback that's pretty serious.
And
Having said that, Mr. Chair, I understand your directive is be creative, be wide in the net for now. Let's get the widest look at we can with what people are doing and figure out what's best for our community.
And we have to look at our needs too, the needs of our community. And our funding for homes is actually some federal funding through HUD called Home Funds. And they are very, very restrictive. And we just need to have that conversation, because I don't know if you could use those funds for example, container housing. I did meet with Ms. Perry the other day to talk about a situation in her district with the Bethel Apartments, which they were built in the late 60s, and they've served this community well for a very, very long time, but they've just really outlived their useful life. And HUD is foreclosing. They've declared Bethel in default, and they're foreclosing on that. There are a few tenants still there. They're trying to relocate those. Those are some of the lower end, low-income housing, and we have a HAP contract for, I believe it's 94 units that's associated with that development, and we can't afford to lose that HAP contract. that provides for 94 homes under Section 8 housing. And we're working now to try and find a property, develop a property to transfer that contract to, because we need to accommodate that segment of our population.
So when you mean transfer that contract, what does that mean exactly?
That Bethel Apartments has a contract with HUD
Okay.
to provide Section 8 housing for 94 units, where HUD actually pays the rent.
Okay.
And there's a formula on what percentage of the rent they pay based on the person's income. They pay the major portion of the
I
rent.
get that point, so, but we need to replace
And
those
so-
units.
Yes.
On that continuum we said, where you and I would agree home ownership is the top, this was, again, no judgment for it, but it's at the least end, because it's the most incented some other way than us, and the most controversial for people around. Obviously, there's a pejorative attachment to that. What Kay's saying is, we got to have that. There's a need for that, and so we have to replace it. If we even, and they worked diligently for 2 years on this straight, I've watched them just labor through this. You couldn't put Bethel back, because it's in a flood, so you could never put back what was there after it's been burned down. It's just been mistreated by the group managing it. It's so much. Last week, while in Baton Rouge, I went and met with Commissioner Barra, and we are talking directly with them, direct as you can, to make sure that Office of Community Development, OCD, that we get those back. So to the extent they can put us in line and have some of that ready, we're doing it. But I know they have gone through a lot of reputable people trying to do it. Nobody could make it work. We need it. Whether it needs to be at that site or not, it can't be, because you couldn't build it and make it accommodatable.
But can't
in that
you,
flood.
I mean, but could you tear it down and build it up, then rebuild it?
You would
Not for
have-
the cost.
You would have to raise it.
About 2 or 3 feet?
Yeah.
Right,
because
2 or
of
3
flood.
feet, and it's cost prohibitive to do it.
Okay.
To develop on that property. The most effective and economical thing is to move to another
Okay.
location.
I know that's your.
And so we've talked.
Are we going to tear those down once they move out?
I'm sorry.
HUD would have to be the one to do
Oh.
that.
Yeah, they got to be torn down,
So it's
right?
going to go through foreclosure with HUD,
Yeah.
and, you know.
We can't just have
who
those
knows
units, those empty
whether
units
No,
there.
we-
I said that.
You
purchase
can't, you
it,
can't have that.
Or if HUD will end up with it, because no one buys it at the sheriff's sale. That's a bridge we'll have to cross, but believe me, it's on our radar.
Mr. Fowler?
With thought in mind, and not to change completely what you're talking about, the unique type of housing, like the tiny homes and such as that, with our code and restrictions in mind, could we use something like our overlay, if it were properly done, to be able to do in smaller sections of town?
So you could, probably less overlay and more some kind of planned urban developments or diverse corridors that we would create in conjunction with communities. You'd really, so think, Alex, when we did that, we kind of had that laid out, some of that, where people would be open. But that would take a massive amount of community input from us and working with people. You're going to get pushback from everyone. It's not just not in my neighborhood because my house, I'm rich or poor. It's going to be everyone, because it's different and it's going to be a challenge. We're gonna have to-
Mr. Mayor, so if I understand you correctly, 90-something units are going offline,
Correct.
and we're trying to put together a plan to replace them,
Correct.
Right.
And have been for 2.5 years.
but nothing is definite.
Nothing is definite at this point, and if we don't get this money through the Office of Community Development, there's some disaster recovery money there that we're asking them to reallocate for this special project, and if we don't get that, then we're not going to be able to replace those in time.
Now,
It has to be done within 2 years of the default, and
We're close to
we'll
that.
put it in February of
Of next-
27.
Okay.
So
Well,
we
we got
don't
a lot of time.
have a long
No.
window there. Now, if we are unsuccessful in getting this funding from ODC, then we can transfer those, we can break it up and transfer the contract in piecemeal among developments that already exist. We'd rather not do that because we're losing 90 units that people desperately need.
Exactly.
And I'd like for it to be back
The
in
96,
District 3.
yes.
In District 3,
Absolutely.
you know?
So our commitment would be to work with Madam President, it's her district,
Right.
to where, I mean, you're going to get pushback from somebody if the new development spot is apartments next to somebody. It's going to take work. It's going to take a lot of, but what can't take time, what we have to hurry up with is to identify the funds to get the commissioner and them to see it. Look, they have a bunch of money they didn't expend. They ought to be wanting to do it because they want it off their books as bad. But you can imagine the rules for this. It's like, we all want it, but who wants to check and dot every I and cross those Ts to do it? So we're trying to, we gave them a timeline that they built, which we're happy to share, what happened in the timeline, and presented it to them, said, you can fact check all this, go for it, here's where we are.
And when we spoke yesterday, I told them, I want it. Let's do it. Let's make it happen. Let's not put it somewhere else because my district need it. And so both of them said, we're going to try our best to make it happen. And so whatever it takes for all of us to work together to get it done, then that's what's going to happen.
Yeah, okay. All right, well, I just want my fellow council members to know that I'm going to be working with the administration, and I'll be putting, we'll be formulating a program, various programs. So expect to hear from me and the administration in several weeks to come. I've been working with Mr. Goins also. He's connected me with a gentleman in Shreveport, and we've been kind of meeting and
Regarding affordable housing?
regarding affordable housing. So we got some work to do, man. We got some work to do. I think we can get the work done, and I think the people of Alexandria will be pleased with the end result. So let's just get to work and make it happen. So are there any additional
Thank you, Mr.
comments? Additional comments? All right. All right, well, Mr. Fowler? All right. Matters adjourned. Committee's adjourned.
It's 1702.
It's somewhere, huh?
Right. I will. The Alexandria City Council meeting is called to order. Alexandria City Council meeting and council committee meetings are broadcast live and may be viewed live by the public on Optum Cable Channel 4. A rebroadcast may be viewed on Optum Cable Channel 4 in the City of Alexandria website, which is www.cityofalexandria.com. We'll have the invocation by Councilman Lawberdane and the pledge by Councilwoman Felter.
Everyone, please close your eyes and bow your heads. Dear Heavenly Father, we thank you for this day. We thank you for this moment. We thank you for this opportunity. Crown our heads with wisdom and make sure that we put the people of Alexandria first. Let us stress that we're here to better the city for everyone.
Yes, Lord.
Understand that we may be disagreeable at times, but let's not be ugly about it, and let's make sure that we are handling the people's business.
Pray, man, pray.
Thank you, Jesus, for traveling grace here, and we're going to thank you
Yes.
in advance for us to all get home safely.
Yes.
In your name I pray, amen.
Amen.
Please face the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands,
one nation, under God, indivisible, with liberty and justice for all. Before we begin, I would like to recognize Councilman Jules Green, the passing of his wife, Miss Osa. We would like to have a moment of silence for Miss Osa Green, please. Thank you. Miss Osa's service will be Saturday at 11 o'clock at the St. Francis Cabrini Cathedral.
No, the church. Xavier, St. Francis Xavier.
Texas Avenue,
The cathedral. Oh, it's Cabrini, I'm sorry.
Texas Avenue, Cabrini.
Sounds cathedral.
Was that what I said? St. Francis
Madam President,
Cathedral?
you had it fine. There's two.
Okay.
St.
So
Francis.
Cabrini,
On Texas
Cabrini on
Avenue.
Texas, the church associated with the school, not the cathedral.
Yeah.
Okay, on Texas Avenue. Okay, well, that's will it be at 11 o'clock.
Okay.
And I think the viewing is from 9:30 until 11. Also, before we go any further, I would like to make this announcement. The mayor had spoke about the House bills last week, and Mr. Judge Sterling wanted me to announce that House Bill 249, he had actually made a request that Representative DeWitt introduce House Bill 249. He wanted everyone to know that it was intended to amend Act 121 of the 2023 legislature section, and that it was contained an explanation. He had sent all the council members an email concerning that House bill, and he wanted to let us know that it was to benefit the city of Alexandria. He wanted to be transparent about it and to let everyone know that whatever he did, and it was to benefit the citizens of Alexandria. So thank you, Judge Sterling, for calling me and for sending the emails, and we know that you have a reputable reputation. Thank you. Okay, and Madam President, can we have roll call?
Mr. Johnson?
Here.
Ms. Felter?
Here.
Mr. Green? Mr. Fowler?
Here.
Mr. Ballard?
Here.
Mr. Lawberdane?
Present.
Ms. Perry?
Here.
Madam President, you have a quorum.
All right. We have approvals of the minutes taken from a regular meeting held on May 6th. I need a motion, please.
Move.
A second.
Second.
Motion by Councilman Fowler, second by Councilman Ballard. We have any public comments? Mr. White?
Yes, ma'am, Madam President.
Yes, sir.
First, I want to thank you for telling us about Jules Green. I didn't know anything about that, and we need to pray for that family and everything. And I just want to remind some people too, Memorial Day is coming up Monday, so we need to think about all the vets that sacrificed their life for this whole country. Friday also, at the Rapides Parish Sheriff's Department, they're going to be honoring all the fallen officers. So that's going to be Friday at 10 o'clock at the courthouse. Now, on the minutes, and I'm so glad that you said about Richard giving you all that email. I wish he'd come down here and talk to us.
Let's stay on task, Mr. White.
That's what I'm saying.
You're doing
That's
good.
what I'm saying.
You're doing good, so let's stay on task.
Well, I'm just saying, I just wish he would have come and
Well, he
Explain.
said that, now Judge Sterling did say that. If you have any questions, that you can reach out to him, and I'll gladly give you his number so that you can call
No,
him if
well,
you
I
have any
mean,
questions.
it's too late now. It's down there in the legislature, and it's going to be
That's
properly
okay.
passed, and then the governor's going to sign. But the thing with it, a couple of weeks ago when we had the meeting, which I wish Malcolm would have let some of the public speak on this last thing, but on the last meeting, he let the public speak on 2 items, then he wouldn't let the public speak anymore on any other items.
Okay.
And I was just wondering, was there a reason for that, Mr. Malcolm X?
Time?
Okay,
Yeah,
so,
'cause
but
we
public comment ought to be,
That was during a
Express.
committee meeting.
That was
yeah, I know when, but
Right.
just like when he was asking, could he, somebody, because I wanted to speak about the poor, because the poor on some of this stuff is going to be really hurt. But I'm glad,
Mr.
Madam President, that you're looking after the community, and I didn't know Bethel was in that bad of a shape.
Thank
But,
you.
The only thing is, and I hope all the mothers had a happy and blessed Mother's Day
Thank you.
the Sunday before.
Thank you, Mr. White.
Can we,
Mr.
I
White?
still wanted to know, can we get a vote on having no, Mr. Guest, I wanted to vote to let people know, we used to have public comment.
And I told you, you asked me about, after the meeting, could people have public comments? And that answer was no. I asked all my
Oh,
colleagues,
okay.
yes, sir.
So
I
y'all
asked-
don't want nobody to have public comment
Not
like it used
after-
to be years ago?
No, sir. When the
Okay.
meeting is over
Thank
with,
you,
the
ma'am.
meeting
That's
is
all I
over
need to know.
with.
Thank you.
You're
Thank you,
welcome.
Madam.
All right. Discussion? All in favor? Any opposed? Motion carried.
We have a consent calendar. Number 1, introduction of an ordinance authorizing the mayor to accept the low bid submitted for Clemson Company. Number 2, introduction of an ordinance authorizing the mayor to accept the low bid for fire hydrants and accessories. Number 3, introduction of an ordinance authorizing the mayor to accept the low bid submitted for fire station number 4, roof leak repairs. Number 4, introduction of an ordinance authorizing the mayor to accept the low bid submitted for annual uniform bid for the police department. Number 5, introduction of an ordinance authorizing the mayor to enter into a contract with COVID Software Incorporated to be utilized by members of the Alexandria Police Department to obtain information relating to the criminal justice information services. Number 6, introduction of an ordinance authorizing the mayor to accept the lowest proposal received from U.S. Lines of Alexandria for landscape maintenance services for 3rd Street Rain Garden. Number 7, introduction of an ordinance authorizing the mayor to accept the lowest proposal received from U.S. Lines of Alexandria for landscape maintenance service for Rapides Trail. Number 8, introduction of an ordinance authorizing the mayor to accept the lowest proposal received from Yankee Holding, doing business as Yankee Clipper for landscape maintenance services for Holocaust Park. Number 9, introduction of an ordinance authorizing the mayor to accept the lowest proposal received from Taylor Scapes for landscape maintenance services for Compton Park. Number 10, introduction of an ordinance authorizing the mayor to accept the lowest proposal received from U.S. Lawn of Alexandria for landscape maintenance services for Bolton Avenue Rain Garden. Number 11, introduction of an ordinance authorizing the mayor to accept the lowest proposal received from Taylorscape for landscape maintenance service for Alexandria Gateways. Number 12, introduction of an ordinance authorizing the mayor to accept the lowest proposal received from Taylorscape for landscape maintenance services for Acadian Park. Number 13, introduction of an ordinance authorizing the mayor to accept the lowest proposal received from Taylorscape for landscape maintenance service for HDQ Park. Number 14, introduction of an ordinance rescinding ordinance number 18, 2025 for janitorial supplies. Number 15, introduction of an ordinance authorizing the mayor to renew the corporate endeavor agreement with the State of Louisiana Department of Veterans Affairs. Number 16, introduction of an ordinance authorizing the mayor to enter into a contract with Clearview AI Incorporated to be utilized by members of the Alexandria Police Department during criminal investigation. Number 17, introduction of an ordinance to enter into a contract with Genesis Protect Connect Incorporated to be utilized by members of the Alexandria Police Department for inter and inter-agency communication.
Need a motion, please? Second.
Second. In committee?
Motion by Councilman Fowler, second by Councilman Ballard. Any items of committee?
Number 15, finance.
We assigned it.
Mhm.
We
They
assigned it.
sign it.
Okay.
That's all? Okay.
Yes.
For the resolutions.
Okay, resolutions. Number 18, resolution authorizing advertisement for bid for spun pre-stressed wood pole equivalent concrete pole.
Motion, please.
Move.
Second.
Motion by Councilman Ballard, second by Councilman Fowler. Public comments? Discussion? All in favor?
Aye.
Any opposed? Motion carried.
Number 19, resolution authorizing advertisement for bid for annual bid current model year vehicles bid current model year or new.
Motion, please.
Move.
Second.
Second.
Motion by Councilman Ballard, second by Councilwoman Felter. Public comments? Discussion? All in favor?
Aye.
Any opposed? Motion carried.
Number 20, resolution authorizing advertisement for bids for annual uniform bid for the fire department.
Motion, please.
Move.
Second.
Second.
Motion by Council Fowler, second by Council Ballard. Public comments? Mr. White.
Thank you, Madam President.
You're welcome. And Mr. White, all you have to do at this time is state your name.
Oh, yes, ma'am. Mr. Cornelius Lawson White Jr., 3638 10th Street, Alexandria, Louisiana, 71302. My phone number is area code 318-446-6934. Madam President, I hope we'll be dealing with Kaplans. We try to deal locally, so I don't know where the fire department gets their uniforms, but I assume that Kaplans.
We're not on that item yet. Mr.
No. I mean, it's talking about the bid.
Yes, sir.
To get, so are we going to be doing locally with the local? People.
Louisiana law.
Okay, but no local?
We observe Louisiana law.
This is too.
This is
Okay,
advertising.
well, that's all I was just asking. We say shop local, buy local.
We will, when we get there, you know, Mr.
All right.
White. Thank you. Discussion?
Yes, I have a discussion.
Mm-hmm.
I do hope that local companies will bid for this item so that we can keep local, but it's in their, when we put it out for bid, it's their responsibility to bid to us. So I do hope that they do bid because I would like to keep it local.
Absolutely.
I think we all feel that way.
Yes.
Local. All in favor?
Aye.
Any opposed? Motion carried.
Number 21, resolution authorizing advertisement for bids for pole mount transformers.
Motion, please.
Move.
Second.
Second.
Motion by Council Ballard, second by Councilman Johnson. Public comments? Discussion? All in favor?
Aye.
Any opposed? Motion carried.
Number 22, resolution authorizing advertisement for bid for single-phase pad mount.
Motion, please.
Move.
Second, please.
Second.
Motion by Council Fowler, second by Councilwoman Felter. Public comments? Discussion? All in favor?
Aye.
Any opposed? Motion carried.
Number 23, resolution authorizing advertisement for bids for three-phase pad mount.
Mo- Second, please.
Second.
Motion by Councilman Councilman Johnson, second by Councilman Ballard. Public comments? Discussion? All in favor?
Aye.
Opposed? Motion carried.
H, ordinances for final adoption subject to public hearing. Number 24, adopt and levy 2025 millage rates.
Motion, please.
Move.
Second.
Second?
Motion by Councilman Ballard, second by Councilman Fowler. Public comments? Discussion? All in favor?
Mr. President, Madam President, I'm sorry, we need a roll call vote on this item, please.
Okay.
Mr. Ballard,
Yes.
Mr. Lawberdane.
Yes.
Ms. Perry,
Yes.
Mr. Johnson,
Yes.
Ms. Bellard,
Yes.
Mr. Green, Mr. Fowler.
Yes.
Mr. Ballard.
Yes. I voted twice.
Motion carried.
So that's 7-0?
Motion carried.
No, 6. 25, to consider final adoption of an ordinance authorizing the mayor to accept the low bid submitted for gas meter and Itron ERTs.
Motion, please.
Move.
Second, please.
Second.
Motion by Councilman Ballard, second by Councilman Fowler. Public comments? Discussion? All in favor? Any opposed?
Hey, hold up. I signed up for this. Y'all don't have the paperwork?
It's an 8.
Yeah, you got signed up for 28, Mr. White, not number 23, 25, unless you want to change it.
No, we
No,
can't
we
change
can't
it.
change it.
Can't change it.
No.
No.
I circled 25, but you say I got.
Yes, they are smart meters.
That's an 8.
Well, I circled 25, but you say I'm on 28?
Yes.
Okay.
Okay, motion carried.
Number 26, to consider final adoption of an ordinance authorizing the mayor to accept the low bid submitted for herbicide.
Motion, please. Second.
Second.
Motion by Councilman Fowler, second by Councilman Johnson. Public comments? Discussion? All in favor? Any opposed? Motion carried.
Number 27, to consider final adoption of an ordinance authorizing the mayor to accept the low bid submitted for ready-mix concrete.
Motion, please.
Move.
Second.
Second?
Motion by Councilman Ballard, second by Councilwoman Felter. Public comments? Discussion? All in favor?
Aye.
Any opposed? Motion carried.
Number 28, to consider final adoption of an ordinance authorizing the mayor to accept the low bid submitted for operating supplies for the electric distribution department.
Motion, please. Motion by Councilman
Fowler.
Fowler, second
Second.
by Councilwoman Felter. Public comments? Mr. White.
What it was, that was supposed to be 25, so I.
Okay, it's all right. You can move on.
Okay.
Thank you.
Discussion? All in favor? Any opposed? Motion carried.
Number 29, to consider final adoption of an ordinance authorizing the mayor to accept the low bid submitted for janitorial chemicals.
Motion, please.
Move.
Second. Motion by Councilman Ballard, second by Councilman Fowler. Public comments? Discussion? All in favor? Any opposed? Motion carried.
Number 30, to consider final adoption of an ordinance authorizing the mayor to renew the contract with Underground Utility Supply LLC for chlorination equipment for the water department.
Motion, please.
Move.
Second.
Second.
Motion by Councilman Johnson, second by Councilman Ballard. Public comments? Discussion? All in favor? Any opposed? Motion carried.
Number 31, to consider final adoption of an ordinance to establish a hearing bureau and administrative procedure to adjudicated code violations related to blighted and abandoned property, public health, housing, fire prevention, and the environment, and other matters with respect thereto.
Motion?
Move.
Second.
Second.
Motion by Councilman Lawberdane, second by Councilman Ballard. Public comments? Mr. Washington?
Ms., would you like to hear your public comment first, and then I'll bring the amendments?
Yes, please.
Okay.
Good afternoon, council,
Good doing.
mayor, administration. My name is Reddix Washington, and I just want to say that I am in support of this ordinance number 31. for several reasons. First, I believe that it'll work well with what we see going on in Baton Rouge right now with House Bill 234 that is currently going through the Senate that is targeting blight, as we see that blight has been a problem. I also believe that it will help with economic development, which we all hear about. I believe it'll clean up our neighborhoods, it will attract new businesses, and it will create safer neighborhoods. And at the same time, it would save the city money, possibly on demolitions. And the other thing about this ordinance is it's not anything new. It's something that I've seen done in many other cities in Louisiana. So we would not be recreating the wheel. We would just be going with the motions of what other cities are doing. So I just wanted to say thank you to Daniel for working on this and the administration for working on it. And as a citizen, I'm glad to see this going forward, and hopefully that you all vote for it. Thank you.
Thank you, Mr. Washington.
Thank you.
Mr. Trey, Mr. Gist.
Thank you.
Thank you.
Madam Chair, the administration, legal department have a couple of technical amendments that we mentioned in the committee. The first amendment will be, and you'll notice in your books, we have already prepared an appropriate title that is a little longer than the title in the fact sheet that was just read. We would offer an amendment, or we would suggest that amendment should be offered to provide, the title should read, an ordinance to enact Article 12 of Chapter 7 of the Alexander Code of Ordinances to be comprised of Section 7-231 through 245 relative to abandoned and blighted property, semicolon, adjudication and enforcement, semicolon, to establish a hearing bureau and administrative procedures to adjudicate code violations, semicolon, providing for definitions, semicolon, declaring blighted property unlawful, semicolon, authorizing enforcement for violations, semicolon, providing for appointment, comma, authority and powers of hearing officers, semicolon, establishing procedures for hearings, comma, notices and orders, semicolon, establishing penalties and costs, semicolon, rights of appeal, semicolon, providing for liens and enforcement remedies not exclusive, semicolon, records and matters related to transfer of ownership and other matters with respect thereto. This technical amendment should be the title, and it is shown in your books.
Where's it shown in our books?
Show,
No, that's not the,
it's not the fact sheet, it's the ordinance attached.
In the very back.
on the very back? Oh, on the ordinance.
Where it has the,
You can amend that
This,
first.
we'll have this in the back. All of this,
page 1 of,
yes.
13.
That's right, page 1 of 13,
That's it. All of
the
it.
title.
Thank
You want,
you.
you want two amendments or one amendment?
I recommend this be done in Globo,
Okay.
along with a recommendation from Mr. Larvadain that page 5 of the document, draft, section 7-237, procedure for hearing, in paragraph B, that the time be at least 30 days, that's 30 days, and not 15 days. That's the time for notice to the alleged violator. Mr. Larvadain has requested that, and the administration and the legal department have concurred with that. Mr. Daniel Smith has also indicated that he has recently modified the definition of blighted property. Ms. Jones has already included that definition in the draft on page 3. Those are the technical amendments from the matter that was previously introduced 2 weeks ago. I believe it would be in order, Ms. Chair, that the matters be considered in Globo unless there's a call for a division of the question.
I'd like to amend as suggested.
Second.
And also, are we going to incorporate provisions for forced heirs and the sick and elderly now, or would that be done later?
That'd be you and Mr. Smith will work on we'll offer those favorably in the amendment you want.
Okay, all right. I'll work with Smith. Thank you. All right.
I have a feeling that this will be amended
Yeah.
more than once.
Yeah.
Yeah, because it's
It's new. It's new, so.
Okay,
We did public comments already.
we did public comments. Discussion, all in favor?
I just want to say
No
something. on
discussion.
I noticed, I want to thank Kay, she, in the committee, was talking about doing it, I think, attacking one area at a time, like I think Cynthia brought it up years ago. That way, if we clean out one area instead of jumping from, area to area, one house here, one house there, I think it's a great idea, and I want to thank her for, bringing it up, so we get stuff done.
Yeah, I agree. I think it makes an impact, something you can really see
Yeah.
change.
Madam President, on behalf of the Legal Division, I just want to thank Attorney Daniel Smith. We're very fortunate to have someone with this level of expertise here at the city, and he is responsible for bringing this into place, so I just want to thank him.
Well, Daniel. I want to also.
Thank you.
I want to thank Daniel and Mr. Goins. I want to thank the administrator. I want to thank Mr. Laverdane, who is passionate about this as well. And I want to thank my colleagues and the administration. When you have teamwork and you don't see any eyes, as you see tonight, we made things happen. And so when you work collectively together, then we get things done. And so tonight, we got things done as a team, and I like that. So thank everyone. Let's continue to work as a team.
Got a good quarterback.
Yeah.
I knew it. All right, so, any opposed? Motion carried
On the amendment.
on the amendment. All in favor?
Aye.
Motion carried.
Now we need to have a motion in a second as amended.
As amended, okay. Second?
Second.
Moved by Councilman Fowler, second by Councilman Ballard. Public comments, discussion, all in favor? Any opposed? Motion carried. Okay, you done?
No, number 32.
On that one.
To consider final adoption of an ordinance authorizing the mayor to renew the existing contract with Kaplan's Incorporated for annual work uniform for various departments.
Motion, please.
Move.
Second?
Second.
Did you say
Y'all
third?
want to approve that?
Fourth? Motion by Councilman who? Valord, second by Councilman Johnson, third by Councilman Fowler, fourth by Councilman Felter, fifth by Councilman Perry.
Let's have a roll call vote.
Discussion, Mr. John, you make me look good. And, and we just want to thank you for all that you do for the city of Alexandria and how you make all of us look good. And we do appreciate you, and we like to keep things local, and we definitely like to keep you local. All right.
Hey, Mr. John, would you come up here so the people can see you? So they'll know who you are?
Mr. White, he's good.
Mr. White,
He's
Mr.
good,
White, you're
Mr.
not
White.
touching me.
He's good. Thank you, Mr. John. Okay, all in favor, we support him. All in favor?
Aye.
Any opposed? Motion carried.
Wait a minute, I was supposed to have public comment. That's-
Oh, you got a public
Yeah.
comment? Come on, Mr. White.
That's why I was saying, if, the people need to know who you are. That's, Mr. John, you ought to come up here so people can see
Mr.
you
White.
and know who you
It's
are.
not your meeting.
It's our meeting.
I know it's y'all's
All
meeting,
right, come on.
but the public
Come
public
on.
needs to know, and we need to support Kaplan's. I bought many clothes from Kaplan's and as military police and stuff like that, so we're supporters of local businesses. Buy local, stay local.
That's right.
That's why I wanted Mr. John to come up here and just, so people could see you, man. You don't need to be behind the scenes. All right, thank you.
Thank you,
God
Mr.
bless.
White. Meeting adjourned.
No, I'm not.
Oh, and also, we would like to remind you that the city will be putting on activities, fun, party in the parks, at different parks. And the first party in the parks will be Friday, June 6th at the Martin Park, 4222 Elliott Street, from 11 to 2. Please let the kids know that they will have a party in the parks, June 6th, in Martin Park. Thank you.